Standing for the doxology, Philippine National Anthem, and the Supreme Court hymn to be performed by the Supreme Court Choir.
Vostra pace. Lord, make me an instrument of your peace. Dove c'è odio, lasciarlo seminare l'amore.
Magiliw, pwede sa silanganan, alam ng puso, sa dibdib mo'y buhay. Lupang hinirang, duyan ka ng magiging. magiging sa manlulupig, di ka pasisihil sa dagat at bundok, sa simoy at sa langit mong lugaw. May dilagang tula at awit sa paglayang minamahal, ang kislap ng watawat mo'y tagumpay na nagdidingding. Ang bituin at araw niya kailan pa may di magdidilim, lupa ng araw ng walit pagsinta mo ay langit sa piling mo. Aming ligaya na pag may mga api ang mamatay ng dahil sa'yo. Behold the curtains of arise, and robed in majesty and light, uphold the fundamental law. From this writ all their judgments flow. With conscience free their views to air, they vow and this to all declare. Rich or poor, friend or foe alike, the scales ever balance strike. Justice and equity for all, law, truth and fairness reign their hall. There stands the court of last resort, forever Supreme Court, with vision set on history. Their vision leaves a legacy, for their honor, their faith, their names, the nation will all acclaim. Justice and equity for all, law, truth and fairness reign their hall. There stands the court of last resort, forever Supreme Court, with vision set on history. Their mission leaves a legacy, for their honor, their faith, their names, the nation will all acclaim. For their honor, their faith, their names, the nation will all acclaim.
Please be seated. Thank you, Supreme Court Choir. Good afternoon, Your Honors, friends, ladies and gentlemen. I'm Court Administrator Jose Maidas Marquez, and I'm honored and pleased to be your Master of Ceremonies for this afternoon's event. To formally welcome us to the 16th Metrobank Foundation Professorial Chair Lecture, may I call on retired Supreme Court Justice and now Chancellor of the Philippine Judicial Academy, Justice Adolfo S. Ascuna.
Thank you very much, Justice Jose Maidas P. Marquez, our Court Administrator. The Honorable Justice Antonio T. Carpio, often acting Chief Justice, and the leader in this gathering today of the best and brightest of the Philippine judiciary. Palakpakan natin si Justice Carpio. Thank you po. The other members of the Philippine Supreme Court, led by our Speaker, Justice Incoming Senior Associate Justice. Bakit kayo natawa? Diosdado Peralta, our Speaker, big hand. The better half of Justice Dado, Also a Justice Fernanda Lampas Peralta of the Court of Appeals and their family. The Honorable Justices of the Sandigan Bayan and the Court of Appeals and the Court of Tax Appeals who are here present. Palakpakan natin ang appellate justices natin. The frontliners of the Philippine judiciary, our judges in the RTC and municipal courts, who are the backbone of the Philippine judiciary. Let's give them a big hand. Officials of the Office of the Court Administrator, the JVC, PHILJA, different offices of the Supreme Court. And before I forget, our development partner, the Metrobank Foundation, let's greet its president, Aniceto Sobrepeña. Chito. Chito and I were together for many years in Malacanang, so we know each other very well. And we have been in the forefront of serving teachers. That's why he gave us this teachers decal, because it is Teachers Month from September 5 to October 5 every year. And October 5 is Teachers Day. And this Metrobank Foundation lecture, which is our event today, is a foundation grant by the Metrobank Foundation to the Philippine Judicial Academy to develop the teachers of the Philippine Judicial Academy. Let's give a big hand to the Metrobank Foundation. I'd like to greet also the Vice Chancellor of the Philippine Judicial Academy, my colleague, Justice Romy, our hard-working Justice Romy Callejo Sr. of the Philippine Judicial Academy, who is our reactor today. Mga kaibigan, magandang hapon po sa inyong lahat. To you there up in the gallery, good afternoon to everybody. We just came from Cape Town on a very strenuous trip, 10 hours to Doha, 10 hours from Doha to Cape Town, in order to attend a 5-day seminar workshop of the International Organization for Training, Judicial Training, IOJT. There, the three of us, Justice Dado, Court Ad Maidas, and myself, attended so many sessions on the latest development in judicial training. What we can take back is that judicial training has three aspects. First is the remedial or substantive law, training on substantive and remedial law. Second is training on skills, no longer the law but emphasize on skills. And then the third, which is the latest, is training on social context. A judge cannot deliver his or her judgment in a vacuum. Judgment is delivered in a social context, and therefore there is a training on outreach, how the judiciary should reach out to the community. This is part of our reaching out to teachers and the teaching community. So this is a very valuable lesson that we bring back from Cape Town as we reassemble for this annual event. This is already the 16th Metrobank Foundation lecture. 16 years na ginagawa ito. The title of our lecture today is The Significance of Recent Developments in Criminal Law, Procedure, and Jurisprudence in the Philippine Judicial System. But if you look at your program, the title reads this way: The Significance of Recent Developments in Criminal Law, Procedure, and Jurisprudence to the Philippine Judicial System. We did this on purpose because of the dual nature of the lecture today. It's like quantum physics. There are two states. And first is the significance in Philippine judicial system of these developments. But more importantly, the significance to the Philippine Judicial System of this recent development. So it is a very exciting lecture, multi-layered and with a double-bladed thrust. So it is my happy privilege to welcome you and to look forward with you to this very exciting lecture. Again, magandang hapon po sa inyo lahat. Thank you.
Thank you, Mr. Justice Ascuna. Let us now hear the message of the President of Metrobank Foundation Incorporated, Mr. Aniceto M. Sobrepeña.
Honorable Justice Diosdado M. Peralta, 2008 Outstanding Filipino Police Officers Judge, the Honorable Antonio T. Carpio, Senior Associate Justice, 2004 Outstanding Teachers Judge, and 2010 Outstanding Filipino Soldiers Judge, Honorable Adolfo S. Ascuna, Chancellor of the Philippine Judicial Academy, 1990 Outstanding Filipino Teacher Judge, Honorable Romy Calleja, Vice Chancellor of PHILJA, 1996 Outstanding Filipino Teacher Judge. So we're very happy that most of the people involved in this event have served in the Metrobank Foundation search for outstanding Filipinos since 1990. Court Administrator Maidas Marquez, colleagues from the Metrobank Group, other guests, members and faculty of the Philippine Judicial Academy, our partner, judges, justices, friends, ladies and gentlemen, magandang hapon po sa ating lahat. Our distinguished chairholder today, the Honorable Justice Peralta, has the noble task of maintaining balance in our judicial system and ensuring that the scales of justice are not tipped in anyone's favor. There's no denying about the relevance of today's lecture, which will present the significance of recent developments in criminal law, procedure, and jurisprudence in and to the Philippine judicial system. Justice Dado will discuss at length the intricacies and nuances of certain criminal cases, providing us with a clearer understanding to which is the very core of the annual Metrobank Foundation Professorial Chair in Law, which is to give insights and new learnings in topics that shape the national landscape. Going through the summary of his lecture, it will center on the interplay of the three branches of the government, executive, legislative, and judiciary, in the development of criminal law. Judicial reforms, as we all know, has always been evolving. Thus, it requires a holistic and collaborative approach between and among these branches. I am particularly interested to know more about the concept of restorative justice, one that does not label crime as against the state, but rather asserting offenders' rights and privileges in order for them to get reintegrated back into our society. The Philippine Judicial Academy has and continues to be an excellent partner in the delivery of these lectures, which serve as a means of capacity building and promoting excellence in legal education for both legal practitioners and the general public. We at the Metrobank Foundation sincerely believe that having an educated citizenry has a high multiplier effect and is one of the keys to nation building. Equally important in nation building is the quality of the very judicial system that governs the state. Public servants like Justice Peralta work tirelessly to protect its integrity and keep the balance of delivering justice and protecting human rights. Undoubtedly, the lives of Filipinos are dependent on how the wheels of justice turn, regardless of what side they are on. It is only fitting that early on in our lecturer's career, he was a prosecutor at Regional Trial Court, Manila Branch 49, which received a reputation as the fastest in resolving cases. Justice is delivered when one receives what he or she deserves. The lecture at its heart is about the changes our judicial system has undergone to better serve the people, wherein wrongdoers are held accountable, restored, and sent back as contributing members of society. The nation-building task continues to evolve. This year marks the 40th founding anniversary of Metrobank Foundation with the theme Puso at Sigasig, or Heart and Zeal. Both values are perfect embodiments of the late Dr. George S.K.T's corporate vision and approach to nation building, as he was first and foremost driven by his heart for the community and the zeal to use his business as a force for the community's good. 40 years later, together with his successors, the heart for the community has started it all. That started it all continues to be the rallying front. Never tires, never falters, never stops, and sustained by the flame of zeal and kindling on and towards the unwavering commitment to excel, engage, and empower communities. And to all the professors, instructors, and teachers in this hall, let me greet all of you a happy National Teachers Month. We have two taglines, my teacher, my hero. And our advocacy is very simple in the Metrobank Foundation. Throughout this period, say, thank you, teacher, to at least one of your teachers, past or present. In closing, may I request you now to watch our audiovisual presentation, A Heart That Serves.
A generous heart is a great equalizer. When a heart cares, serves, and transforms, it can help improve people's lives and grow communities. Generosity is at the heart of what we do at Metrobank Foundation. Our founder himself is a generous man. He had said, "I make money, so I give money back." Since day one, Dr. George S.K.T. has been guided by the belief that wealth, once made, is meant to be shared. He saw many opportunities to make things better for the Filipinos. All it would take, he said, is heart. Thus, Metrobank Foundation has been envisioned to be the country's premier corporate philanthropic organization that contributes a significant impact on social development. To do our work well, we rely on our roadmap: excel, engage, empower. We aim to uplift individuals and link up with like-minded institutions for a shared purpose. We also aspire to propagate a culture of excellence and provide solutions to the needs of our stakeholders. Through the Metrobank Foundation Outstanding Filipinos, exemplary teachers, soldiers, and police officers are recognized for rendering service above and beyond their call of duty.
We could not discount the importance of heart in public service. Being a soldier, your capital is your life. You should not hesitate. You should not have a second thought in the performance of your duty, because soldiery is more than a profession. You are laying down your life.
The heart is actually the core of our public service. The heart teaches us to unselfishly give service to the people who we are committed to protect and to serve. It is a sense of satisfaction when you are able to use your heart and see people smile and having fun because of what you did.
Here in the Philippines, there are a lot of people who are marginalized and underserved. We have a lot of opportunities to work for them. So I think when you say heart in public service, it's really knowing who you work for, and at the end of the day, you know you serve these people.
The annual Metrobank Art and Design Excellence hails the creativity of the Filipino through the annual competitions in painting and sculpture.
Yeah, heart is actually passion, more on passion of doing the artwork, my passion of creating works that will touch the society, heal the society. That's for me is having a heart. Having heart in whatever it is you're doing will fuel that creativity. I'm fortunate enough to work with students and teachers who are already creative in their own right. The output is a manifestation of the creativity, wherein if they put a little bit of time and effort to that, plus that heart, will make an outstanding art piece.
The Metrobank MTAP DepEd Math Challenge is our way of helping students become competitive in mathematics.
As a student and a mathlete, it is perseverance and passion that make me excel. Perseverance is actually hard work and discipline. On the other hand, passion is the drive to pursue something in spite of difficulties and failures, and the will to stick to it in the long term.
We provide financial assistance to underprivileged but academically deserving students.
Holding on to the principles of honor and excellence, because excellence is nothing without honor, and honor is important because not only are we scholars of the university, but we are scholars of the entire country. Therefore, it is our responsibility that we have to not only be a part of, but to contribute to the community that we are in.
We encourage different sectors of society to pay tribute to the teaching profession through the National Teachers Month. We work with like-minded organizations whose programs are aligned with our health, education, arts, and livelihood thrusts towards the attainment of sustainable development goals.
I think heart is the beginning of any creative endeavor. It allows you to be empathetic, sympathetic. It allows you to be compassionate. It's the current that actually helps you translate something intangible into something tangible, which is an artwork.
Heart, really, when we are dealing with people, we have to deal with empathy. It's not enough that if we wanted social upliftment, it's not enough that we give money or material things. They have to feel that they are part of this.
It is essentially what separates social work, social development work, from the regular development work. You deal with people, you deal with their hopes, their dreams, and you try to find out their strength and build on that so that eventually they could be self-reliant, and that's very important in sustainability.
Calzada Coffee champions Philippine specialty coffee. We wanted to be the calzada, or the road from farm to cup, and bridge the coffee farmers to the market. We basically wanted to put Philippine coffee back into the international market, not just in terms of volume, but also in terms of quality. It's very important to be able to understand the needs of the people we support. And we can only hear them if we use the heart. It's not only listening through the ears, but more importantly, through the heart.
Through our grants program, we help raise the quality of life of the poorest, most vulnerable, and underserved sectors of society. We aid survivors of natural calamities in the Philippines and Asia through relief and rehabilitation efforts. Serving as our healthcare arm is the Manila Doctors Hospital, offering social services to indigents and health interventions in adopted communities.
The work that we do has limitations in itself, but when we harness and maximize generosity, it can play a huge role in meeting the needs of society. By generosity, we don't mean only monetarily, but also the heart to share time, talent, and skill. Only then can we equal the kind of heart that contributes to the greatness of our country.
be a leader in philanthropy may come naturally to Metrobank Foundation. But the bigger vision is to be the soul of philanthropy in the country. That is where our heart truly lies.
Thank you, Mr. Sobrepeña, for your inspiring message and audio-visual presentation. To introduce this year's Metrobank Foundation Professorial Chairholder, may I call on no other but the 178th Justice of the Supreme Court, Mr. Justice Alexander G. Gismundo.
Thank you, Court Ad Marquez. I need not restate the greetings made by Chancellor Ascuna to save time. I was tasked to introduce this afternoon's lecturer, but I was saying to myself, to formally introduce this afternoon's lecturer is a superfluity because his credentials and achievements can be taken judicial notice under Rule 120, what need not be proved, so to speak. I need not recite the litany of his accomplishments, as it may consume more time than his lecture. A condensed version of his biographical profile is attached to the program. But for those who wish to read the full version, you may visit the Supreme Court website at www.scjudiciary.gov.ph. His expertise in criminal law and criminal procedure is reflected in his precedent-setting ponencias. He is an itinerant lecturer of the Philippine Judicial Academy on various topics. Our lecturer's experience as a public prosecutor, a trial judge, an associate and later presiding justice of the Sandigan Bayan, and as a member of the highest court, prepared him well to become an effective chairperson of the Supreme Court's several committees, tasked to craft and promulgated special rules of procedures, as well as the revision of the existing ones. Friends, fellow students of law, fresh from the JBC interview, let us listen to the 16th Metrobank Foundation Professorial Chair Lecturer, soon-to-be Senior Associate Justice, Honorable Associate Justice Fernando M. Peralta.
Thank you very much, Justice Alex, for a brief introduction. This time I will not cry. Honorable Antonio Carpio, Senior Associate Justice of the Supreme Court. Of course, my good friend Alexander Gismundo, Associate Justice of the Supreme Court. Honorable Adolfo Ascuna, Chancellor of the Philippine Judicial Academy. Honorable Romeo J. Callejo Jr., Vice Chancellor of PHILJA, one of my mentors. Jose Maidas Marquez, Board Administrator, and who has now a new name. I can now call him Dr. Marquez, for attending to me for 3 days when I suffered a pulled calf muscle where I could not get out from my room for 3 days and I could hardly walk. So he attended to me by bringing ice and medicine just to drive away the pain that I was suffering from. Of course, Mr. Aniceto Sobrepeña, President of the Metrobank Foundation Incorporated. The first time that I met him when I was chosen by the Metrobank to be a co-chairperson of the Search for Soldiers. But probably he does not know that as early as in the mid-90s, when I was working for a corporation, because of the trust that they had given to me by my employer, I used to deposit a lot of money in your Metrobank Caloocan. And I remember your branch manager there He became a vice president. He became a president of one of your subsidiaries in the name of Mr. Henry Su. You remember him? Yeah, he knows me very well. In fact, he was surprised when we became ninongs. That after so many years, he was surprised that the young Dado that he met in 1993 and 1994, he was already, in 1974, 75 and 1976, he's now meeting a Dado who was already an RTC judge in Quezon City. I heard that Henry So already retired. Yeah. Of course, the Honorable Justices of the Court of Appeals, I will include my wife, of course, and my daughter, the Sandigan Bayan, they're all here. Justices, and also from the Court of Tax Appeals. Our developmental partners, I see him over there. Yes, sir, why are you standing? Why not take a seat? Yeah. Good afternoon. The Court of Professors of the Philippine Judicial Academy, Justice Oswald Agkawili, where is Justice Magtolis, and the officials of the PHILJA, those who were attending to me when we have lectures in the provinces, where are they? I think they are all here. Oh yeah, they are all here. And of course, the SC officials and my favorites, the first level and the second level courts in Metro Manila. Most of you are all here. I wanted to ask you, why is it that you are not attending to the continuous trial? And I see also judges from Mindanao. Yeah, from Marawi. She's here. Thank you for coming. I will, anyway, in the course of my lecture, I will show to you how we have performed in our continuous trial system. Distinguished honorable judges, of course, the distinguished guests, ladies and gentlemen, a pleasant afternoon to all. In a democratic system of government, such as in the Philippines, laws are enacted as rational responses to the ever-changing needs and parameters of social concerns. This is particularly true of penal statutes, where the complex problem of tempering human rights and punitive measures in relation to the actual dispensation of justice does not lend itself to a simple or individual solutions. This balancing act requires a congruence of corroborative effort among the three branches of government towards the maintenance of justice that is fair, impartial, and responsive. This lecture intends to focus on the interplay of such effort between the legislature, the judiciary, and the executive. It aims to give the participants a concise but comprehensive overview of the interchange of initiatives between the branches of government in the development of criminal law, with particular emphasis on judicial reforms that have been adopted to address the persistent twin concerns of cost of case delay, docket congestion as regards criminal cases. The present state of Philippine criminal law will likewise be discussed, with particular emphasis on the recent penal statutes enacted by the legislature and the recent decisions, resolutions, and procedural rules by the Supreme Court in connection therewith, in line with its thrust of emphasizing the concept of restorative justice over the archaic retributive justice. The adjustment of penalties in the revised penal code. In 2014, in the case of Corpus versus People, the Supreme Court, faced with the issue of the constitutionality of Article 315 of the revised penal code pertaining to the crime of estafa and its corresponding penalties, contemplated on the perceived injustice brought about by the range of penalties that the courts continue to impose on crimes against property committed today based on the amount of damage measured by the value of the money 80 years ago in 1932, and the resulting enactment of Republic Act number 10951, which addressed the need to adjust disproportionate and outdated penalties in the revised penal code. Corpus was charged with the crime of estafa defined and penalized under Article 315 of Paragraph 1, for failure to remit or to return several jewelries within a period of 30 days in the amount of 98,000 pesos. When the said period expired, without corpus paying nor remitting to complainant, a complaint for estafa was charged against him and he was convicted by the regional trial court. He was sentenced to suffer a penalty of 4 years, 2 months, to 8 years plus 7 years, because under the old law, or even under the new law now, we observe or we follow what we call incremental penalty in a crime of estafa, or also in a crime of theft. So the penalty then at that time was the penalty for estafa is prison correctional maximum to prison mayor, which carries a penalty of 4 years, 2 months, and 1 day to 8 years. But because the amount is 98,000 pesos, and therefore there is an incremental penalty of for every 10,000 in excess of 22,000, then an additional penalty of 1 year. So he was convicted to suffer a penalty of 4 years, 2 months, and 1 day to 8 years plus 7 years. So the penalty was 4 years, 2 months to 15 years of reclusion temporal. On appeal to the Supreme Court, Corpus contended that the penalty imposed upon him by the Court violated the Equal Protection Clause and the prohibition against oppressive and cruel punishment. The legislature apparently pegged the penalties to the value of the money and property in 1930 when it enacted the revised Penal Code in 1932. Since the members of the division reached no unanimity in this question, and since the issues are of first impression, they decided to refer the case to the court and bank for consideration and resolution. He thus asked the court to suspend the execution of sentence or amend the same to accord respect to his constitutional rights. The members of the Supreme Court and bank presented different approaches to the problem presented by this case. In his opinion, Justice Robert Abad, who was known to be an innovator and now retired, voted to affirm the conviction, but with the modification of the indeterminate penalty to 2 months of arresto mayor as minimum to 1 year and 8 months of prison correctional as maximum, entitling him to probation. Said Justice, in short, he was saying that we have to change the amount of the value because the value of money in 1930 is no longer the value of the money when the accused committed the crime. And he said that penalty is oppressive, is unjust, we have to declare it unconstitutional. I registered a different opinion. I said that the premise of the revised penal code anticipated that someday the penalty may become oppressive and unjust. And the premise were intelligent enough, I said, that the solution is found in Article 5 of the revised penal code. And then the solution is, I said, we should not encroach the power of the legislator to declare that unconstitutional and for us to give the penalty, because that will be tantamount to judicial legislation. Anyway, I said, Article 5 provides that if the penalty becomes excessive, then the remedy is to write or furnish a copy to the Secretary of Justice so that the Secretary of Justice can inform the President. And I said that is found under Paragraph 2 or Article 5 Revised Penal Code. Fortunately, my decision was carried by the Banc. That decision is dated April 29, 2014. That was promulgated in 1914. On August 29, 2017, RA 910-951 was enacted into law, effectively amended 97 articles of the then 87-year-old revised penal code. In other words, because one of my objections at that time is that if we declare that unconstitutional, what penalty will we be imposed? If we will be the one to impose the penalty, I think we do not have power to do that. And I also argued that when you determine the penalty, there are three things that we have to remember. One is the nature of the crime, the relation of the crime to the other crimes, and the value of the property. That's why probably some of my colleagues sided with me. But mind you, because we furnished copies, the chairman of the Committee of Justice in the lower court, the chairman of the Committee of Justice in the Senate, the Speaker of the House, the Senate President, I think Senate President Rilon was then the Senate President, and not long after, enacted this 10951. And they now fix the amounts based on the value of the peso when they enacted this law. So what happened then? If you look at the penalty, comparison of the penalty of estafa under the old law and the new law, it will show the amount of fraud on the left side. Let us take the example of the case of people of Rolando Corpus. If the amount exceeds 12,000 pesos, but not exceed 22,000 pesos, then the penalty is prison correctional maximum to prison mayor minimum. But if you look at the penalty now, under the new law, if the amount is 98,000 pesos, where's now the penalty? Because that 12,000 pesos was changed to 2.4 million pesos. So if the amount of the fraud is between the amounts of 2.4 million to 4.4 million, the penalty is prison correctional, it is maximum period to prison mayor maximum mayor minimum. So that means that the amount of 12,000 became 2,400,000. That amount of 22,000 became the amount of 4 million. So this is what I'm saying, an interplay between the judiciary, the legislative, and of course the executive, because it's the executive that enacts the law. Now, but the problem is, even if the law became effective, what about those who were already languishing in jail? What will they do? Yes, it may be applied, it should be applied retroactively because that's favorable to the accused. But how about those who were sentenced to a penalty of reclusion perpetua? The domestic helpers who have been charged with qualified theft under Article 310, where the amount will require the imposition of the penalty of reclusion perpetua. What about those who have been sentenced to a penalty of reclusion temporal? What will they do? What will they do? So in another case that followed, this is a case of Hernan versus Sandigan Bayan. It was a case that was assigned to me in the division. Now, okay, this is the case of Hernan versus Sandigan Bayan. The accused in this case was a disbursing officer of the Department of Transportation and Communication, Baguio City. He was convicted by the Sandigan Bayan, and the penalty imposed was prison mayor minimum, that means 6 years and 1 day, to 11 years, 6 months, and 21 days. And the amount disbursed by him was only 11,000. 11,000. But that case of Hernan has become final and executory as early as 2013 because the lawyer probably filed a wrong petition. Because before the amendment of the internal rules of the Sandigan Bayan, the manner of raising the issue of conviction, if you want to be acquitted, it was then under Rule 45. And that was a discretionary appeal. Probably the period has already expired. What the lawyer did he filed a petition for certiorari under Rule 65, which is a wrong remedy. So if the wrong remedy, then he cannot told the prescriptive period to file Rule 45, and therefore that judgment became final and executory. But because of this law, 10951, I brought this case to the Banc. I said that we will take cognizance of this case not for the purpose of acquitting the accused as prayed for, but for the purpose of correcting a penalty by virtue of a supervening event. And my colleagues entertained that case, and for the first time, after the effectivity of 10951, we ruled that from here on, this law should be given retroactive effect under Article 22 of the revised Penal Code. So what we did, because even if we rule that it is already effective, and therefore Hernan should not be convicted of a penalty lower than the penalty imposed by the court because of the effectivity of 10951, I was faced with the dilemma. Because what remedy would those accused serving sentence in Bilibid? The only remedy that you can think of is that they will file petition for a writ of habeas corpus. But if you do that, then all the cases, all the judges located near the penitentiary where they are incarcerated will be flooded with petitions for writ of habeas corpus. The other one is, can a judge of an RTC in Muntinlupa amend the judgment has already become final, because that will be the basis of granting a petition for a writ of habeas corpus? I said, I think he cannot. It is only the Supreme Court that can reopen a case that has become final and executory. So I ruled in that decision, I said, we advise that all those incarcerated that they should file their petitions before us so that we can reopen. Not for the purpose of acquitting, but only for the purpose of imposing the proper penalty under RA 10951. True to my apprehension, because after we rendered the decision, there were already several petitions that were filed before us. Ang dami. So the problem now is, anong gagawin natin dito sa dami? So through the efforts of Justice Francis Hardalesa, later on, in the case of Rolando El Banbuena y Marfil, because we were already flooded with several petitions, we came out with a guideline to be followed by judges of the RTC in Muntinlupa, because that's where the National Penitentiary is located, and also judges within the jurisdiction of Mandaluyong, because we have a National Penitentiary there, and also in Davao. So we came out with a guideline. It's now easier, instead of petition for writ of habeas corpus, they just follow the guideline. We give them the authority to amend their decision if they fall under 10951 and then release the accused. Several hundreds of accused benefited from those cases of Hernan and Marfil. In fact, we are still receiving. Not only that, we advise the justices of the Court of Appeals that those cases of qualified theft where the accused is not entitled to bail, they should now grant bail because bail has become a matter of right. And then we also advise the second level courts, especially the RTC, that they should give preference to these cases, because we know that there are a lot of cases involving theft, robbery with force upon things, estafa, that are pending before their courts, so that they can be resolved as soon as possible, especially those who are undergoing preventive imprisonment. Now, the other issue that I raised during that case of Rolando Corpus is that I said that if we fix the amounts now on our own, what will happen with the other special laws, where the penalties also are dependent from the penalties under the crime of theft or estafa? Because like the violation of the SSS law, the SSS law provides the penalty of estafa. The revised Parity Code, the penalty is dependent on qualified theft under Article 310. The anti-fencing law, in fact, I said that there may be a problem on the anti-fencing law because anti-fencing law is actually an accessory in the crime of terror of estafa. But the penalty of anti-fencing law is higher now because the law does not provide for any amendment on the fencing law. But because of this 10951, I believe that these laws have been effectively amended because the penalties are dependent under the revised penal code. Now let's go to the amendments to the law on probation. Okay. Now, probation is a special privilege granted by the state to a granted to a penitent qualified offender. Jurisprudence on the matter treats appeal and probation as mutually exclusive. In other words, if you file an appeal, then you lose your privilege to apply for probation. Every judge knows that. And that is a provision under Section 4 of the Probation Law, which states that no application for probation shall be entertained or granted if defendant has perfected an appeal from the judgment of conviction. In other words, appeal and probation exclusive. It cannot be applied all at the same time. You have to make a choice. Okay? But in the case of Colinares versus People, after his conviction by the trial and appellate courts for the non-probationable crime of prostrated homicide, for the benefit of everybody, prostrated homicide is punishable by prison mayor, which carries a penalty of 6 years and 1 day to 12 years. So you cannot apply for probation because the lowest penalty, the lowest maximum penalty that you can get in a prostrated homicide is between the penalties of prison mayor medium, which is 8 years and 1 day to 10 years. So definitely you are beyond the coverage of probation. But the crime of prostrated homicide was downgraded by the Supreme Court to attempted homicide. Therefore, the penalty now is prison correctional, which is 6 months and 1 day to 6 years, where the penalty now is probationable. Okay. The separate concurring and dissenting opinion submitted by the Supreme Court Okay. The separate concurring and dissenting opinion submitted that the Supreme Court may now allow Colinares to apply for probation because Justice Abad, who was again the ponente of this, he said that I'm looking for his ponencia, where he said that if the accused is convicted by the lower court for a crime of prostrated homicide and then appeals, then he's forever barred from applying for probation under paragraph 4 of the new law, of the law on probation. But he said, but supposing the judgment says that he should have been convicted of attempted homicide and then the RTC was wrong, why should he not be entitled to probation? Or there might have been mistake on the application of the modifying circumstances in the commission of the crime, where he should have been sentenced a penalty of more or less than 6 years. Is that his fault? He said, That's not the fault of the accused. Then I resisted my own opinion. I wanted to have a compromise with him because I said that when you file, if you file a notice of appeal and the appeal is perfected, the court loses jurisdiction. Where will you file the application for probation? Go back to the court. The law does not say so, I said. So I came out with a compromise. Ganito na lang para hindi tayo mag-away-away. If the accused appeals only for the purpose of correcting the penalty imposed by the local court, I think we can agree on that. Or if the court was wrong in appreciating the circumstances or the mitigating circumstances, and therefore the penalty should have been probationable, and then he appeals only for the purpose of determining the proper appreciation, mitigating circumstances, sabi ko, yes. But if he appeals the case to convince the court for an acquittal, as I said, I think that cannot be done. Because the probation is not a penal law, it cannot be given liberal interpretation because the probation law, the grant of probation is merely a privilege, it's not a matter of right. But I lost in the voting, so my opinion became a dissenting opinion. So what happened? So all those who appealed, and then the decisions were modified to a probationable period, they go back to the court and then apply for probation. But later on, in the case of Di Makuta, which I wrote the decision. Di Makuta was convicted by the lower court for violation of 7610, no? That means sexual abuse. He was convicted and he was sentenced to a penalty not covered by probation law. He went to the Court of Appeals. The Court of Appeals modified the sentence and they say that the law violated is not 7610 but 366 of the revised penal code, otherwise known as the crime of acts of lasciviousness. And you know what's the penalty of acts of lasciviousness? Mababa yun eh. Probationable. So, when Di Makuta was convicted by the Court of Appeals, he now applied for probation in the Court of Appeals. And you know what the Court of Appeals did? The Court of Appeals denied the application for probation. But there was already a case of Colinares because that case of Di Makuta, I think, was brought to us 3 years after Colinares. But this time, Justice Abad has already retired. And there were more RTC judges, there were more justices coming from the lower court. So, I maintained my opinion in Colinares with the added issues or added reasons. I traced the history of the probation law from the first time that it was introduced during the time of the former president. It was PD 968, I think. And that the first probation law is that it prohibited also the application for probation if you already appeal. But it was amended later on, which is now PD 1257, ibinalik nila. Pwede kang mag-apply ng probation even if you appeal, said. But they realized later on, according to the explanation of PD 1968, that is PD 1968, ibinalik sila, you cannot apply for probation if you appeal. Because they now realize that there were so many appealed to the Court of Appeals where even if they were already entitled to probation, they go to the Court of Appeals and then they are convicted, then apply for probation. So in other words, they were making a mockery of the probation law. So I traced that history. So probably those who were not convinced in the earlier case of Colinares, I was able to convince them So my dissenting opinion in Colinares became the majority opinion in Dimakota. But mind you, kaya very interesting criminal law sometimes. 37 days after that Dimakota case, on November 26, 2015, 37 days after the Dimakota case, President Aquino signed into law RA number 10707. The law is a consolidation of Senate Bill number 2280 and House Bill number 4147, which were passed by the Senate and the House of Representatives on September 15, 2015 and September 14, 2025. Reading probably from the different opinions of the justices of the Supreme Court in the earlier case of People versus Colinares, and probably the latest decision in the case of People versus Dimakota, where I clearly stated that we cannot tread the realm of legislative action. I said the only remedy here is to go to Congress and then have the law amended. And 37 days after, the law was amended. And what do you now see? The amendments of the law. Yeah. Okay. You look at number 4 now. That the old provision is section 4. There is a clear disqualification to apply for probation. But this one now, you can now apply for probation. Even if you appeal, so if the accused is convicted of a crime more than 6 years, and then you appeal, and then the appellate court lowers the penalty to a probationable period, you can apply for probation. But they incorporated my apprehension that might be abuse, I said. So they placed there that those who are convicted of a crime by the lower court, when the penalty is already probationable, and then you appeal to the Court of Appeals, you can no longer apply for probation. So that's not the present law. But I thought then that they will only touch Article 4. But if you look at the effect of probation law, on the last part, please. They included this one. Yeah, termination of probation. You look at section 16, section 16. Okay. The final discharge of the probationer shall operate to restore to him all civilized laws or suspended as a result of his conviction, and to fully discharge his liability for any fine. Any fine. So that's the effect. What you look at now under the new law. The law says, they removed the fine because fine is a penalty and probably it's now included under the place, and to totally extinguish his criminal liability. So you apply for probation and then you comply with the conditions of probation, then your liability will be extinguished. So there are now two schools of thought. Because probation actually, to me actually, is merely service of sentence outside the prison cell. Because the court believes that you can be reformed because of the penalty is merely correctional penalty, you can be corrected. And therefore you do not go to prison. You undergo a community service with certain conditions to be complied with. And therefore, if you have complied completely and fully satisfied the conditions, then you do not go anymore to prison. The court will declare that you have already served the sentence. But what is now the meaning of total extinction of criminal liability? A lot of questions have been asked because when they say that it is a total extinction of criminal liability, as if you do not commit any crime. That's one interpretation. So I do not know if there is an issue that will be raised there. I do not know how our the members of the court will react to that. The only way probably to resolve that is to determine the intention of the, because it invites to interpretations. Okay? You see the interplay of just the judiciary, the legislative, and the executive. Now let's go to plea bargaining cases, in drug cases. In the case of Salvador Estipona Jr., I think all judges know this, Honorable Frank Lubrigo, I always tell him that you have become the most popular judge, Honorable Lubrigo, because your name appears in this CRA. I said, yes, Your Honor, but you reverse me. I mean, at least nandiyan yung pangalan mo. When I was a fiscal, sabi ko, I wanted to raise issues to the Supreme Court and then file a petition for certiorari directly filed with the Supreme Court with the respondent, my judge, who was then Justice Callejo. Kasi I wanted my name also to be in this CRA. Okay, the Supreme Court declared Section 23, as you all know, of Republic Act number 9165, or the Comprehensive Dangerous Drug of 2002, which prohibited plea bargaining in all drug cases and as unconstitutional for being contrary to the rulemaking authority of the Supreme Court under Section 5, Paragraph 5 of Article 8 of the 1987 Constitution. Petitioner Estipona filed a motion to allow the accused to enter a plea bargaining agreement, praying to withdraw his not guilty plea and instead enter a plea of guilty for violation of Section 12. Section 12 is illegal possession of drug paraphernalia, punished by 6 months and 1 day to 4 years, which is within the probation period. But Judge Estipona denied the application because he said that is prohibited under Section 23 of 9165. So that case was brought to us, Supreme Court. I do not know. I think this was assigned to me by the Banc. It was not originally assigned to me, but the justice was retiring. So, ikaw na lang magsulat, sabi sa akin. Because, the court, like the second level courts, we have also problem of so many drug cases, not only in your sala, but also in the Supreme Court. That's the reality. So sabi nila sa akin, decide mo na yan, sabi niya sa akin. So I decided within 1 month. Declared the law, declared Section 23 as unconstitutional, a unanimous decision. But the problem is, what are those cases that would be the subject matter of plea bargaining? Because there are only few. There are only few cases. But most of the cases that reach us, and for your information, there are 100,000 cases a year that are filed before our second level courts. 70%, no? 70% of those cases are, okay, and I will go to that later on. And then, okay, so we sided with the petitioner. We ruled that plea bargaining should be allowed except in reclusion perpetua, life imprisonment, or death. Although the revised rule on criminal procedure allows plea bargaining, even if the penalty is reclusion perpetua, life imprisonment, or death. Of course, we do not anymore impose death penalty, but it's not yet abolished. Okay? So, we justified that plea bargaining has something to do with procedure, and therefore it is within the province of the power of the Supreme Court, and that is rulemaking power. We declare it. Hindi naman sila nag-complain. We never received any complaint from the legislative and from the executive. They accepted our decision. The problem then is this. So, what should be the violations that be the subject matter of plea bargaining? So we consulted the judges, we consulted the Prosecutor General's office, we consulted even from the PDEA, from the police agencies, from the Department of Health, because they will be involved in rehabilitation. We had a conference with then the Secretary Guevara. We told them that this is the plan. These are the plans of the court, but this has not yet been approved, but I will have to bring this to the court. I have yet to convince them and so on, because that's what we do. I cannot on my own make a proposal without the consent of the Supreme Court, because that is a collegial body, I said. So, we agreed to have a plea bargaining framework, and these are now the instances where plea bargaining may be, there are only 5. You look at it. Section 11 is possession. I will, so that you will understand it better. Section 11 is possession of dangerous drugs. No? If one is caught in the possession of dangerous drugs, not more than 5 grams, the penalty is 12 years and 1 day to 20 years. If one is in possession of less than 500 grams of marijuana, the same penalty is 12 years and 1 day to 20 years. So, that should be the subject matter of probation. They have no quarrel. They do not have any objection. This one is the problem that they have been raising, Section 5, because, it is a sale of dangerous drugs. Regardless of the quantity, the penalty is life imprisonment to death. But we included Section 5, but only when the weight is less than 1 gram for shabu, or only less than 10 grams for marijuana. Then we included also Section 13, because the penalty in Section 13 is 12 years and 1 day to 20 years. However, if the possessor is found in the company of 2 or more persons or in a social gathering, then the penalty shall be the maximum penalty of 20 years. So it has not yet reached the penalty of life imprisonment. They do not have any objection also. Section 7, only. Section 7 are visitors or employees in a den. We said that if the accused are merely visitors, okay, we will include that. However, if they are included in a charge of maintainers of den, then we will allow a plea bargaining, because that might affect the evidence of the prosecution. Yun lang, visitor lang. Okay, and then we said that all other penalties of life imprisonment to death excluded from plea bargaining. And then they said that we have some objections, and they said that anyway, sabi ko, this is our rule, so we have to follow. It was a joke actually, but several days after, we came out with a circular, which I will discuss to you later. So, the reality is that it is not a well-known fact that around 49% of the total number of criminal cases that are filed before the courts annually are those involving violation of 9165. And you know how many drug cases are filed in a year's time? 100,000 cases. And around 70% of those comprising drug cases involve violation of Section 5. Sale. Yan ang pinakamarami, sale eh. Okay? Additionally, most of the quantities involved in these cases are less than 1 gram. Itong 70% na sale, karamihan dyan less than 1 gram eh. And then Justices Alex and our senior justice can attest to that most of the cases that reach the court involve Section 5 less than 1 gram. Wala naman 1 kilo, 2 kilos na dumarating sa amin eh. Karamihan dyan less than 1 gram, 0.01, 0.02, 0.03. Hindi ba? So, sabi ko, likewise, doon sa Section 90 of RA 9165, alam mo ang sabi sa Section 90, drug case should be terminated. Yung trial date should be terminated within 60 days. And decisions shall be rendered within 25 days. All a total number of 75 days. Kawawa ang mga judges yan, sabi ko eh. they cannot probably comply with the 60-day period. And the 60-day period is counted from the filing of the information, not from the initial trial. Maawa naman kayo sa mga judges namin. Because sa kanila, you have to understand the position of the judges, I said. Walang increase, increase ang trabaho. And you know, this is too short a period compared to a regular case. Yung regular case, we have 10 months to terminate. And the initial trial is the period to terminate a trial is 180 days from the initial trial. Hindi ba? Bakit ito? 75 days, tapos regular cases. Lastly, ito pa, the Supreme Court statistics show, ito nga, that most of the drug cases that reach the court, sa amin, the court, are those involving the sale of less than 1 gram of dangerous drugs. That can be attested to. And mahirap pa yan, ang daming na-acquit na dumadating sa amin because of the strict compliance of Section 21, 9165. And you know that. Alam niyo yan. And we understand your position. That you have convicted a lot of accused. Di ba? But when they reach us, ano ang gagawin namin if you do not follow the requirements under Section 21, 9165, which is required under a substantive law? Wala kami magagawa. I-acquit namin. So acquit ng acquit, sayang oras, bakit na lang hindi na natin i-include sa plea bargaining? Anyway, less than 1 gram lang naman yan. Sabi namin. So, these were the conditions. At saka, which I told it was asked of me, I said to the committee, and I will repeat what I said. As plea bargaining is the general rule in criminal cases and has been proven to be an effective means of reducing the dockets of the courts, and given the difficulty faced by judges in complying with the 70-day period, vis-a-vis the number of cases involving violations of 9165 filed before the court considered the possibility of including Section 5 of RA 9165 as one of the provisions that should be subject matter of plea bargaining, but only if the quantity of dangerous drugs is less than 1 gram or less than for dangerous drugs or less than 10 grams in case of marijuana. There have been objections raised by the prosecution against plea bargaining in connection with Section 5 of RA 9165, where the quantity of dangerous drugs is less than 1 gram. However, in a resolution issued by the Supreme Court on April 2, 2019, objections to plea bargaining may be raised, and the court should exercise its sound discretion in resolving the same to it. So we told them, if you have any objection to plea bargaining, then you can raise the objection on the ground that the accused is a habitual delinquent. He is a recidivist. He has been coming in and out from rehabilitation center. He is unruly in the community. The evidence of guilt is strong. Then raise those objections and let the judge decide by using his sound discretion. Yun medyo na nahibik na sila ng konti. Okay? Now, you listen, no? Data from the OCA Court Management Office show that from the time plea bargaining was allowed in August 2017, a total of 31,149 drug cases have already been decided through plea bargaining. Those who pleaded guilty under Section 12, RA 9165, underwent probation and rehabilitation, and those who pleaded guilty to Section 15 underwent rehabilitation. Hindi ba ganon? Di ba? Especially the users, no? The users are victims. They're not offenders. We have to help them. We have to rehabilitate them. Put them in the jail for 12 years and 12 years and 1 day for 20 years. A mere possession of 1 gram or 2 grams of shabu, languishing in jail for 12 years and 1 day to 20 years. What will happen to him? He will become a hardened criminal. He will be mixed with hardened criminal. He will also be influenced. He will become a hardened criminal. In fact, we heard that those who are coming out from the jail, ayaw na nilang lumabas dun. Because when they go to the respective places, they are not no more welcome in the community. Yung mga bumabalik ngayon, that's what we heard, some of them. And then, proper procedure in filing number 165. Now, okay. There was a time where the first, I hope that I have more time. I mean, I started at 3 o'clock, I think. So I still have 1 hour and 15 minutes. I hope I can hold you up to 6 o'clock in the evening. Because I'm not yet halfway. My foot has been aching, since this morning. But I think the cure is actually standing. So I do not feel any more pain. I can move. I thought that I could not lecture on the standing position, but yun pala, I'm not feeling any pain anymore. But probably, well, one of the reasons is that I love the crowd. Okay. Yeah. Okay, this is what happened, so that you will also understand, mga judges. You are not supposed to misinterpret our decision. There was a time when our former Chief Justice, Tess de Castro, brought a case before us in the Banc because there were different interpretations on Section 2191-65. Because some say that if the procedure is not followed in section, that should be a ground for acquittal. But the law is very clear naman. Ang sabi ng law, for drug operations, then the operating team shall be, under the new law now, it should be accompanied by a barangay official and a media or a representative from the DOJ. However, if they cannot comply with the presence of these two, they have to give justifiable reasons. And they may have to preserve the integrity of the specimen by marking the specimen in the nearest police station, inventory the specimen, and photograph the specimen. The problem when we have all these cases, inacquit namin eh. Why? They do not take into serious consideration yung Section 21. They do not state in their affidavits of arrest if the requirements in Section 21 are complied with. Ang ginagawa dyan, papaupuin yung police, di ba? Tanong na yung fiscal, forgetting the justifiable reason why they were not accompanied. So if you were the justice of the Supreme Court, what will you do? Can you convict him? That is a requirement under the law. But three of us had the view that there is a constitutional infirmity under this provision. Ako at saka Chief Justice Bersamin, sabi namin, I think there is a constitutional infirmity on this. Why is the law providing for a chain of custody which will eventually raise an issue of admissibility of evidence? Sabi ko, encroachment ito Chief Justice Luke. Si Chief Justice Luke sa rule making Hindi ba? Nakalagay ba sa rule in evidence natin yung specific acts that should be done to preserve the evidence? It will depend on the circumstances Wala tayong sinasabi, kung nakakuha ng bala, markahan mo dyan, ganito, mayroon ba tayo dyan? No, because circumstances differ from the others Yung bala nakuha ng doktor, sinasabi, doktor, mamarkahan mo ba yan? No There are many ways to preserve the evidence Why in this law? Specifically right that you have to do this. But, as collegial body, we have to respect the majority. So what did we do? Okay, you return your case to the first division, then the divisions will have to rule on their own based on the circumstances presented in every case. So, I brought a case to the Banc, People versus Lim. I said, in People versus Lim, so that we said that from here on, in other words, henceforth, police officers should now include in their affidavits of arrest They now have to state in the affidavits of arrest the requirements of the law so that they will not commit mistakes anymore. Sabi ko, and that will work two ways. Why? The cases of the prosecution will now be properly built up, and the accused will now prepare an intelligent defense, because as early as the filing of the information, the accused know already the evidence of the prosecution. And they say that, no, your People versus Slim is a ground for acquittal. That is wrong. In People versus Slim, it is for the purpose of filing the information. That's why we said there that if the policeman does not comply with People versus Slim, you apply Rule 115, Rule 112, Section 5, that if you receive an information and there is no probable cause, you dismiss the case for lack of probable cause, and you have to come out with an extended resolution. So that if the case is dismissed, the fiscal can repile it. So why should it be that is a ground for acquittal? In fact, you, the judges, will now be in a better position to resolve the case, because it will be easier for the judge now to assess the evidence. Why? Because in the continuous trial cases, we now allow the affidavits of witnesses to be their testimony. Direct testimony na yan. Hindi ba mas mabilis? Di ba? That's the essence of People versus Slim. It is not a ground for acquittal. It is the law, Section 21, the non-observance of Section 21, that will cause the acquittal of the accused. Okay? I hope you are enjoying, because wala pa tayo halfway. Okay? But I will give you some observations on Section 21. Okay. Do you know that under Section 9, there are some problematic areas that I raised, and I hope that this time, in a hearing last Monday in our budget, because I've been asked about some possible amendments in RA 9165, and then I told them some, then we will go back tomorrow, because we want to help also. We want to help everybody. Nag-aaway-aaway na eh. Sabi ko sa kanila, Your Honor, ang solution dyan, i-amend eh. Sabi siya, can we talk? Kako, we cannot talk about possible law. Privately na lang, sabi ko. So these are the observations that have to be looked into. Okay, now. Okay, under Section 98 of 9165, there is a limited application of the dangerous drugs law. The law says that the provisions of the revised penal code shall not apply to this law. Only when the minor offender, and the penalty is life imprisonment to death. If the offender is a minor and the penalty is life imprisonment to death, then the penalty to be imposed should be reclusion perpetual to death. What is the implication of that? If you remember the earlier case of People versus Martin Simon, in as early as 1974, penned by the late Justice Regalado, he said that if a special law, this one is a special law, adopts the nomenclature of penalties under the revised penal code, then the revised penal code shall apply, as long as it is not inconsistent with the nature of a malum prohibitum. I repeat, if you look at Section 98, the law says if the penalty is life imprisonment to death, then it will become a penalty of reclusion perpetua to death. So the penalty now is converted to a penalty under reclusion perpetua to death. And what did the Supreme Court say? If the crime adopts the nomenclature of penalty under the revised penal code, then the revised penal code shall apply. I will just illustrate it through the blackboard. Please, yung live impia. Okay. You look at this one. Sale of drugs by a minor offender. Let's say that the minor offender sold 5 grams. Therefore, it's not covered by plea bargaining. The penalty is life imprisonment to death. But because of Section 98, It will now become a penalty of reclusion perpetua to death, a penalty under the revised penal code. What is the implication of that? The implication of that is that once he's a minor offender, he will be automatically entitled to a 1 degree lower of his penalty under Article 68 of the revised penal code, paragraph 2. So it now becomes reclusion temporal, where the penalty is 12 years and 1 day to 20 years. He will likewise be entitled to the indeterminate sentence law, where the minimum penalty will now come from prison mayor, and the maximum penalty will now come from reclusion temporal. If there is no Section 98 on this, you can just imagine, if he's a minor and there's no Section 98, the penalty cannot be lowered by life imprisonment, because life imprisonment is not a penalty under the revised penal code. Okay? Now, let us take the case now of another example, no? That's why I'm suggesting, okay, this one. Let's take the case of a minor. Possession of 3 grams of shabu. The penalty is 12 years and 1 day to 20 years. The revised penal code will not apply. Why? Because the penalty is not life imprisonment to death. You cannot convert the penalty under the revised penal code, because Section 98, you only convert it to reclusion perpetua is life imprisonment to death. Now, where will you get the minimum penalty? You cannot lower it by 1 degree under the indeterminate sentence law to get the minimum. The answer is found in the second sentence of Section 1 of the indeterminate sentence law, where the law says, if that is the penalty, then the minimum shall be taken, not less than, then the minimum shall be taken from 12 years and 1 day, and the maximum shall be taken from the penalty of 20 years. So the judge is given a leeway of choosing the minimum and the maximum within the range of penalty of 12 years and 1 day and 20. You can just imagine. But the law says, under 9344, Section 6, that if the offender is between the ages of 15 and 18, and he acted with discernment, he will be entitled to privilege mitigating circumstance. Saan mo ilalagay ngayon? Saan natin ilalagay yan? Some will say we will apply because he's a minor. Some will say no, because where will we apply? Why? Number 1, there is no such thing as a penalty of 12 years and 1 day to 20 years in the revised penal code. There is no 1 degree lower to 12 years and 1 day to 20 years. Diba? Sa revised penal code. And there is no provision in the article in RA 9165 that it should be lowered by 1 degree. Anong gagawin natin? See, these are the reasons. Okay. Let's take another example. Okay. 12 years and 1 day to 20 years. Okay. Illegal possession of less than 5 grams of shabu by a minor offender in social gathering. The penalty is 12 years and 1 day to 20 years. But if the minor is caught in a social gathering or in the company of 2 or more persons under Section 13, then the maximum penalty shall be imposed. Anong gagawin natin dyan? The straight penalty of 20 years. It will become a penalty of 20 years. And therefore, it violates the indeterminate sentence law. Because the indeterminate sentence law clearly provides that if it is an act punishable by any other law, a special law, then the court shall impose a minimum penalty not lower than the penalty provided for by law and not higher than the maximum penalty provided by law. But Section 13 says the maximum penalty shall be imposed 20 years. Worse if it is like this. It is even better, if we follow the penalties, it is even better for a non-minor to kill a person and charge a crime of homicide. Well, let us see. A crime of homicide committed by a 20-year-old boy. The penalty under 249 is reclusion temporal, where the range of the penalty is 12 years and 1 day to 20 years. Let us assume that there are no mitigating or aggravating circumstances, then the maximum penalty will come from reclusion temporal medium, which is 17 years, 4 months, and 1 day, there should be 1 day, to 14 years, 8 months, and 1 day, to 17 years, 4 months. That's the medium. Okay. Applying the indeterminate sentence law, the losses courts are mandated to impose a indeterminate sentence, a minimum penalty to be taken from any of the periods of the penalty next lower in degree, which is prison mayor. And the range of prison mayor is 6 years and 1 day to 12 years. And the maximum penalty shall be taken from the penalty provided for by law after you have taken into consideration the modifying circumstances. So if I am a judge, who is compassionate, and I'm really a compassionate judge, I can impose a penalty of 6 years and 1 day as the minimum. And impose a maximum penalty 14 years, 8 months and 1 day. What is the implication? 6 years and 1 day, if I behave properly, I can already be the subject matter of parole. I will already be released on parole under the indeterminate sentence law. But you look at a minor, 17-year-old minor, penalty is 12 years and 1 day to 20 years. You cannot go lower than 20 years and 1 day. Why? That is a penalty, not a penalty under the revised penal code, right? And there's no penalty next lower in degree to 12 years and 1 to 20 years because graduation of penalties only pertains to the provisions of the revised penal code under Article 61 of the revised penal code. So they have to look on this. I told the Senate last time, they said that we have to talk privately. Hindi lang yun eh. Hindi lang yun. Okay. Para mabilis tayo. You look at prison mayor and then reclusion temporal. Yung number 1 iha. Penalty under the revised penal code. Para mabilis tayo. Then I will discuss na lang. Yung next slide na may graph. That one, yung susunod. Sige pa. Sige pa. No, tungkol sa Okay, I will just discuss now. Now, under the juvenile law, the Juvenile Welfare Act, an information may be filed against a minor when the penalty of the crime charged against the minor is a penalty more than 6 years, then an information will be filed. There may be no diversion in the meantime, and information will be filed. However, if the penalty of the law does not exceed 12 years, di ba? Sino mga family court dito? That exceed 12 years, then the court shall suspend the arraignment. That means if you suspend the arraignment, you also suspend the trial. And he will undergo a diversion program properly managed by the court. If he is rehabilitated, what will happen? The case against the minor will be dismissed. Will be dismissed. Now, if he is now charged with a crime, let's say 12 years and 1 day to 20 years. Let us assume he's charged with a crime. Under the law, the penalty is 6 years and 12 years and 1 day to 20 years. O reclusion temporal na lang. Okay, this one, RPC. If the minor is charged with reclusion temporal, which is 20 years and 1 day, he can still undergo diversion program because there is a reduction of a penalty by 1 degree, which will now become 6 years and 1 day to 12 years. The proceedings will be suspended, then he will undergo diversion program. Now let us see this penalty. 12 years and 1 day to 20 years. Can you suspend the proceedings? You cannot. Because the penalty is more than 12 years. Can you reduce it to prison mayor? You cannot. That's not a penalty. Under the, you see? So these are, of course, they will say that we have to afford him because he's a minor. But some will say, what penalty are we going to impose? Because if I remember right, the penalty lower than 12 years and 1 day is 6 months and 1 day to 4 years. That is the lowest penalty, lower than 12 years and 1 day. Illegal possession of drug paraphernalia under Section 12. Saan mo ilalagay yan? So anyway, these are my observations. I hope that this will be corrected so that our minor children can enjoy the benefits of a minor offender, so that he can easily be rehabilitated. Now, that's why my suggestion is that bakit na lang hindi natin i-adapt yung penalties ng revised penal code like in the old law under RA 6425 during our time with Justice Callejo, when I was his fiscal and he was my judge. At that time, the penalties were under 6425, where the penalties under the law. Then I asked them, bakit nyo kasi pinalitan? And they say, all these smugglers, transporters, maintainers, drug lords will not be meted a lower penalty because they will not be entitled to mitigating circumstances. Ang sabi ko, no, that cannot be done. I said, why? Sabi nila, okay. It will, let's take the case of a penalty of reclusion perpetua. Let's take the case of reclusion perpetua to death. Yeah. Reclusion perpetua to death. No, yung privilege muna. Yung una, okay. This is a minor offender. The penalty is reclusion perpetua to death. Will he be entitled to 1 degree lower? Of course, because that's now the penalty under the revised penal code, in line with the doctrine laid down in People versus Martin Simon. Let's take the second example. Non-minor with one or more, because a non-minor is not entitled to a privilege mitigating of age na yan eh. That's why I was suggesting yung mga senior citizens sana should be also entitled to a privilege mitigating circumstance eh. Sabi nila, mayroon bang offender na senior? Sabi. So anyway, you look at this one, no? Non-minor with one or more ordinary mitigating circumstances. The penalty is reclusion perpetua to death. He is a smuggler. He is a smuggler. He is a transporter. He is a maintainer of the den. Lahat yan. Will the penalty be lowered to 1 degree? Cannot be. Because he is not a minor. He will only be entitled to ordinary mitigating circumstances. And then they say, but Your Honor, if there are 2 ordinary mitigating circumstances, then the penalty shall be lowered by 1 degree. So they will prove 2 ordinary mitigating circumstances. Sabi ko, you look at Article 13, kung meron mitigating circumstance that could apply to a special law like the dangerous lagyo. Karamihan dyan na mitigating circumstances, intentional crimes yan eh. Wala naman lack of intention to commit so grave a wrong. Wala yan. Passion of prosecution. Wala yan eh. The only mitigating circumstance that I could think of is plea of guilty. There could not be voluntary surrender because all the operations in bypass operation or this one, walang voluntary surrender yan. All are caught in the act. Saan yan bababa? Even assuming that there are 2 mitigating circumstances, it cannot be lowered by 1 degree. Why? Because there is an express provision in Article 63 that regardless of the number of ordinary mitigating circumstances, the penalty cannot be lower than the indivisible penalty. So if there are even 2 or 3, yung smuggler yan, yung trafficker yan, yung transporter yan, he will be sentenced reclusion perpetua. So that is merely a misapprehension and that is a misconception. Hindi totoo yan, sabi ko eh. Then we have been lecturing to our judges that you cannot appreciate ordinary mitigating circumstances in order to lower it lower than reclusion perpetua. The lowest penalty that you can impose is reclusion perpetua. And then the other example. Second example. The second example is that if it is a single penalty of reclusion perpetua, likewise, you cannot impose lower than penalty of reclusion perpetua. So there is no harm if you adopt. And then let's now go to allowance of good conduct. Let's make it fast. But I hope you can bear with me. Okay. I will not talk about the observations lang because there are now 8 cases that have been filed before us, I think, and they've been already assigned for report by the members. So I will just point out the decision that we rendered, and also the differences between so that you will understand better, because there are some provisions there that have to be understood. Okay. Yung preventive imprisonment under the new law, you pay attention to this, no? Under the old law, ang preventive imprisonment hindi kasama sa good conduct allowance. Hindi kasama dati yan. The only effect of the preventive imprisonment is to credit the preventive imprisonment in case of conviction, as long as he abides by and follows strictly the rules and regulation of the institution where he is confined. Inilagay nila dyan. But we do not have problem on that. If that is what they want, we have to respect. That is legislative act. Okay, next. Okay, next. No, wag mong bilisan iha. Yung provision, not that one. Section 1 muna. Okay, hop. Okay. Now, these two, 1 and 2, have been there for a long, long time. There are no. So, if it is a preventive imprisonment, recidivist, convicted previously twice or more, they will not be entitled. Okay. Next. Ito po ang problema ko Credit for preventive imprisonment for the penalty of reclusion perpetua be deducted 30 years In other words, meron ng allowance, good conduct of time allowance if the penalty is reclusion perpetua. Wala po yan dati Wala po yan. Okay, let's go further. Wala yung provision yan. Ang pinag-aawayan ngayon, itong provided finally that recidivists, habitual delinquents, escapees, and persons charged with heinous crimes are excluded from the coverage of this act. I will not make any comment on that, but read it. Okay. Now, there was a case brought to us. I don't know. Hindi ko alam kung sineswerte ako. The only issue then was whether or not in the IRR of the Department of Justice and the DILG, providing for a prospective application of the allowance, good conduct time allowance, that was only the issue brought to us sabi nga nila, mali ang Supreme Court dyan. Sabi ko, every law student knows that if the penal law, or even if it is not a penal law, but it will affect the penalty, then under Article 22, it shall be given retroactive effect, except if, habitual offender. Alam mo yung habitual offender, alam mo yung kung sino yun? Habitual offender applies only to 5 crimes Estapa, robo, hurto, serious, less serious and serious physical injuries and falsification. Sinong habitual offender ngayon sa drugs user? Wala di ba? So anyway, so we struck it down. Now, when I was preparing I was reviewing then all of a sudden there was an investigation in the Senate. So these are my observations. Now, I do not know because if it might raise a question, so I will not answer it. It is for you to answer. Give your answer. But number 1, do you apply the good conduct time allowance to the violation of the dangerous drugs law? Yung section 98, sabi ng dangerous drug law the revised penal code shall not apply but only to minor offenders where the penalty is life imprisonment to death. Number 1. I was looking at the IRR because they changed the IRR. Ngayon, wala akong makita doon So, bahala na. That will be raised as an issue. Okay? Yan lang ang provision ng revised ng dangerous drugs law Okay. The other observation is that under Article 10, sabi doon, offenses which are in the future may be punishable under special laws are not subject to the provision of this code. Sa revised penal code yan This code shall be supplementary to such laws, unless the latter should especially provide the contrary. So can we use now the revised penal code as a supplementary law? Eh sabi dito, unless it is provided otherwise. So you cannot apply revised penal code as a supplementary law to the dangerous drugs law. And then later on, in the aftermath of the recent controversy on good conduct, they came out with this IRR. I just point out some observations lang without any further comment, except to bring them out. Okay. Let's look at the definition of heinous crime now. In the preventive imprisonment, I said, and then the law says that they are, nakalagay doon, habitual delinquents, recidivists, escapees, and those charged with heinous crimes, with heinous crimes, disqualified under this act. But you look at the definition of heinous crimes, it will appear that only those convicted of a crime punishable by death, doon sa taas, yung sa una, yung definition nila, yan, crimes which are grievous, obvious, and hateful to the senses and which by reason, including crimes which are mandatorily punishable by death under the provisions of 9659. And 9659 enumerates 13 heinous crimes. But the penalties there carry penalty of reclusion perpetual to death. Ang mga death lang doon, yung qualified rape. Murder, penalty of murder is reclusion perpetual to death. You only impose the penalty of death if there is an aggravating circumstance. But they are quoting 7659 as the heinous crimes. And why is it that it will apply only where the mandatory death penalty? Now, I'm pointing this out, kayo mga judges, as I told you, if you were under me, when you decide cases, you better specify in your decisions that the death penalty should have been imposed. But we could not impose because of Republic Act 9346. And then include in your dispositive portion, the praise not eligible for parole, because that will mean that the penalty of death has been imposed. Specify na lang ninyo, because that's what they like. You know why they did that? Because they have included reclusion perpetua, a period of 30 years covered by preventive imprisonment. So they have to exclude the reclusion perpetua. Well, anyway, now, the other observations is that those who are disqualified, so preventive imprisonment, yes, nandun, titas mo iha. Credit, okay yan, no problem. No problem, because those are in line with our decision. Ang problema ko lang yung service sentence. Yung service sentence, excluded na yung recidivists, habitual delinquents, escapees, and PDL, convicted of heinous crimes. But under Section 1, as amending Article 29, it says that charged with heinous crimes. But this one, they included it. You ask me a question on that, I cannot answer that because there are now 8 petitions pending before the court. Yun lang ang mga problema in the meantime, okay? So let's go fast because I want to show to the judges how you have been performing. What the court has also been done in order to address court delays in criminal cases. There is a new law, Community Service Act. I don't know if you are aware of this. This was recently signed by the President, RA 11362. Those who are convicted with the penalty of arresto menor, I think, arresto mayor, they do not need to be in prison. They will have to undergo community service, but they will only be titled to that community service only once. Okay? Then let's go further. Now, because this is my pet project. Anyway, it's only brief. To complement the aforementioned body of substantive laws and doctrines and jurisprudence that reinforce our criminal justice system, the Supreme Court, through its rulemaking power, has taken the initiative and issued guidelines, procedural rules to address jail congestion and court delays. One such set of rules promulgated by the court is the revised guidelines for continuous trial. The provisions of the revised guidelines are the result of serious exhaustive consultations with the various stakeholders of the Philippine criminal justice system, justices, judges, court officials, and court personnel, public prosecutors, and public attorneys, among others. Among the salient features of the continuous trial system are the mandatory observance of existing rules pertaining to trial dates, judges, which should be held from Mondays to Thursdays, morning and afternoon, with Fridays as motion days, and the significant provisions on how courts can strictly observe the reglementary periods on arraignment and pretrial and promulgation provided under the rules of court statutes and the Constitution, as this enforce the rights of persons to speedy disposition of criminal cases. Notable innovations, among others, adoption of sworn statements and affidavits as direct testimony of witnesses, subject to additional direct and cross-examination, proposals for stipulations done with the active participation of the court, simultaneous arraignment and pretrial, enumeration of prohibited motions which have to be denied outright, and meritorious motions which should be resolved within 10 calendar days from submission for resolution, specification of the dates for the prosecution and the defense to terminate the presentation of their respective evidence as early as arraignment and pretrial, which cannot be postponed, or if postponed, should be done so on meritorious grounds, with the movant required to terminate the presentation of evidence and the dates allotted to him or her. Oral offer of evidence, objections thereto, and ruling thereon in open court. After the accused has rested his or her case, the immediate announcement in open court, in the presence of the prosecution and both counsel and accused, of the date of promulgation of the decision, which should be within the periods mandated by the Constitution, law, and rules. Now, I will give you the result of some data so that I can explain it better. The data was gathered from our continuous trial monitoring system. Yung data po dyan, accurate, because these are gathered from your respective salas, kayo mga courts, first level courts and second level courts. As what they always say, numbers do not lie. So, if you look at the total, the continuous trial, no, you go first to the total criminal cases. Okay. Yeah, okay. You know, this is a data that we gathered from your own reports. For regional courts, there are 402,171 cases. Now, the data here refers 2 years, no? We gathered the data. We started gathering the data on September 1, 2017, when we implemented the continuous trial system. And we ended on September 1 of 2019. So that 402,171 cases, 2 years yan. For the RTC, 402,171 cases. For family courts, you have the data. You can just imagine how many criminal cases are filed before our courts. In 2 years, 647,667. You divide that by 2, more than 300,000 cases a year, criminal cases. And we have the number of courts. Tingnan mo sa total number of courts. Yung RTC lang natin, 1,046. Ha? Yung family court natin, 48. And a total courts of 2,000, mali, bakit 2,317? May zero yun. Should be only 2,317. Wala yung zero doon. Okay. 2,317. You can just imagine, 647, 667 cases attended to by 2,317. You can just imagine the many cases that are filed before the first level and second level courts. That's why when I was tasked to head the committee, I immediately accepted it because it was really a problem to us. Sabi nila kasi mga judges, walang ginagawa. Sabi, hindi naman ako. Maraming ginagawa ang judges. Okay, so this is now the result. Yung child and family cases, for 2 years, there were 63,488 cases filed. Yung drug cases for 2 years, 197,421. Yung ibang cases dyan sa family court may also involve drug cases eh. Kasi kung minor involved in drug cases, pupunta sa family court. So, an average of 100,000 drug cases a year with only 1,064 cases. And the data will show that in Metro Manila, no, they say that more than 100 to 200 cases a month are raffled to our judges in Manila. That's a reality. Of course, environmental cases. So you have first level court cases, 242,000 lang. Tingnan mo ang RTC. Ang dami. Okay. So we implemented our continuous trial. Next, please. Yung flow chart. First, the flow chart. No, yung flow chart muna. Wala na. Okay. This is the flow chart of a regular case or in a criminal case. 10 months. 10 days to arraign a detention prisoner, 30 days to arraign a non-detention prisoner, 30 days, 180 days, then 30 days, then 180 days for trial, then 90 days for promulgation under the Constitution. You have to resolve a criminal case within 10 months. And let us see how you have performed. Dapat sabi ko I told the Chancellor of the PHILJA that we will invite the first level and second level courts. Okay. You look at this. Before, just look at the average na lang. A detention prisoner should be arraigned within 10 days. Before we implemented the guideline, it was only 6.27% ang nagko-comply. But after we have implemented the continuous trial, it went up to 21.41%. Ilang percent yan? 1,000 yan. More than 100%. I mean, it's almost 300% ang improvement. So malaking improvement. And then the arraignment of an accused non-detention prisoner, 16.16% before we implemented. Now it is 43.13%. How many percent? Malaki, di ba? Now let's go to the trial. Trial. Before the implementation, 180 days. Sus Mariosep, 1.76%. That's why our people, our litigants are complaining. 1.76%. If there are 2,400 courts at that time, only 2 or only 4 were complying with the terminate. But look at the data when we implemented the two guidelines. It's now 26.83%. It has become 27%. 2 years pa lang yan. Okay. And then for promulgation, it used to be 36.91% to promulgate a decision within 90 days. What do you have now? 71%. Ano ba? We have to clap our hands for the first level court and second level court? Yes, very well. Hindi lang ito. You look at this. That's why I ask you to attend. Okay? You look at the length of time to resolve regular criminal cases. And I'm very happy about this. Length of time, no? You look at the 180 days for regular cases. 180 days is only 6 months. But you look at your percentage. You look at it. 82% of our courts were able to resolve within the 10-day period, within a period of 6 months. But we are required to terminate our cases within 300 days, 10 months. And what is your grade? 94.4%. See? Now let's go to drug cases where they have a lot of problems. This one is really problematic. I told you before that let us try our best to comply. 60 days from the filing of the information. Sabi ko, it will violate our rule Because our rules provide that you cannot start with the trial immediately after the arraignment. Because there should be a gap of 1 month from the arraignment to initial trial. Because the purpose of the 30-day period is for the preparation of the trial of the parties and the counsel. Kaya may gap yan So paano mo ngayon magagawa yan? But of course, we tried our best and this is the result. Okay, go ahead. Okay. Arraign the accused within 10 days, 605%. Not so much improvement, 9.05%. Of course, mayroon din improvement. Non-detainees, 20.27%, became 27.70%. Not, there is an improvement. Ito ang nakakuha, no? Within 60 days from filing, before the continuous trial, 0.03%. Kahit na isang court, wala nakakapag-comply. Kaya ang joke ko dyan, pag in-interpret mo, literally, pag sinabi ng isang one court, hindi ka nakaabot sa loob, dikit na ng courtroom. Wala hindi ka nakaabot 0.03 Pati after the implementation, 0.82. But they tried to compensate by complying with the 15-day period to resolve the cases. Biro mo 15 days lang to resolve? But meron din improvement, more than 100%. Okay yan. But you look at the data. Okay. I forgot to tell you pala kanina. This one, on the first column, these were decided before the continuous trial. On the second column, these were filed before the continuous trial, but procedure undertaken during the implementation of the continuous trial. On the last column, filed and decided under the continuous trial. So you can see the difference. When we implemented the continuous trial, it went up to 40%. Decided within the 75 days. Had we been allowed to follow a 10-month period like regular cases, you can just imagine the rating should have been 86%. That's why I was telling my friends in the Senate, maawa naman kayo kami. Sabi, bakit? Hindi ho namin kaya yung 75 days, sabi ko. So I was telling them that if try to amend the law, give us naman 4 months. Sabi nila, can you decide the cases within 4 months? Definitely, we can. Sabi ko. Medyo ako nagyabang But I committed myself, pwede na 4 months, hindi ba? Kung 100 days tinan mo, kung 300 days, 86%, that is 6 months Tanggalin mo lang yung 23 doon, di aabot kayo ng 80%, hindi ba? But still, I'm very much satisfied because I said before, it's very hard to comply, but still, we were able to get a 40% percentage. Okay? Now, lastly, I will just shorten. There is another program that we have been implementing. The proposed guidelines on use of video conferencing for remote testimonies of persons deprived of liberty. Yeah, the in-court appearance of persons deprived of liberty considered to be high risk or afflicted with highly contagious diseases has proposed serious risks to the safety, security, lives, and health of not only the accused and those charged with transporting them between the jail and court, but of judges, court personnel, and the general public as well. The inability to travel to and physically appear in court of those PDLs or persons deprived with liberties, afflicted with serious or grave medical conditions, results in either the postponement of the proceedings or missed opportunities to be present and confront the witnesses against them. As a policy, PDLs committed in national penitentiaries are not allowed to be brought outside said penal institutions to appear or attend proceedings before any court, resulting in either the waiver of the right to be present at any stage of trial or the archival of the criminal case and suspension of the proceedings until the court shall have adopted the appropriate rules. Clearly, there is a need to provide measures to enable PDLs to appear and testify in court without having to leave the jail or national penitentiary. We already implemented on a pilot testing on September 2. On September 2, there's my picture. I think, I'm so sorry to say, the picture of Justice Callejo does not appear in that picture, but he was there when we were trying to implement the video conferencing. We have to go there And you see the judge sitting at the middle. That's me. I was pointing to the TV monitor that was appearing before us, what was happening inside the jail in Davao. So we tested it, became effective. I think we tested it, I think that was last week of August. That was Friday. Last week of August, we went there the whole day. We conducted a seminar in the morning with a demonstration in the afternoon, just what you see. Then after the demonstration inside the court, we went to the city jail and also look at the operation. And I said, okay, good, let's proceed. So we proceeded September 2. We are receiving good feedback. In fact, others would not like, there are now other penitentiaries, they would like that it should not be implemented. But sabi ko, tignan natin maigi because, it's already, we spend a lot of money and then because of the technology, we had a problem. The good feedback that we receive is that if you look at the pictures of the judge and the others, all of them are smiling. Oh, kasi naka-televise na sila eh. They are now smiling. The judge is now very patient. He's not anymore scolding. He's very attentive. He's not anymore using his cell phone during trial. He's very attentive. That's the feedback that we get. So Judge Carpio, you see him, he's smiling. But they say when there was not a camera, he was always scolding. So that's the good feedback that we get. I hope that we can implement to other areas later on because that will shorten the proceedings. It will promote a speedy trial of cases. I therefore conclude that other legislative enactments and the Supreme Court decisions that applied and interpreted them could have been included in this discussion, as they likewise directly affect the development of criminal law in the Philippine Judicial System. These include the pertinent provision of RA 9344 and the automatic suspension of sentence of a child in conflict with the law if found guilty of heinous crimes, as applied and explained in the 2009 case of People versus Richard Sarcia, penned by our retired Chief Justice Tess de Castro, the case of Norma del Socorro, Ernest Johann Brickman Van Wilson. I think the family courts are familiar with this case regarding the issue of whether a foreign citizen residing in the Philippines may be liable for his unjust refusal or failure to give financial support to his child in violation of RA 9262 or the Anti-Violation Against Women and Their Children Act of 2004. I think this is the case that led to the filing of criminal cases for failure to give support under economic violence or psychological violence. So you do not anymore find cases of support that are filed in family courts. They now prefer to file criminal cases under 9262. I think that the judges from the family courts will confirm that. Marami na kayong violation ng 9262. Of course, it is subject matter of mediation, so it's easy to settle. Okay. In the case of People versus Tulagan, wherein the court lamenting that notwithstanding the intent of RA 97610 or the Special Protection of Children Against Abuse, Exploitation, or Discrimination Act to provide for stronger deterrence and special protection against child abuse, the penalty when the victim is less than 12 years old, which is reclusion temporal in its medium, is lower compared to the penalty when the victim is 12 years old and below, which is reclusion temporal in its medium period to reclusion perpetua. Held that a corrective legislation is the proper remedy to address the noted incongruent penalties or acts of lasciviousness committed against a child. However, given the limited time allotted to this lecture, the recent laws and Supreme Court rules and decisions as regards the adjustment of penalties, probation, plea bargaining in drug cases, the reduction of sentences, deprive of liberties based on good conduct time allowance, community service, continuous trial, and the use of video conferencing technology in conducting testimonies were selected not only because they are aligned with the efforts of the judiciary to decongest court dockets and address case delays, they were likewise selected because they greatly affect the rights of the accused to life and liberty. More importantly, the laws, rules, and decisions that have been extensively discussed were chosen for their emphasis on a shift to approach towards crime and criminals. With the advent of modern age and liberalism, the idea of justice that is hinged on punishment and vengeance, known as retributive justice, is slowly being replaced by one that focuses on reparation and reconciliation, the concept of restorative justice. Rather than focusing on the concept of crime as an act against the state, where the penalty imposed theoretically corresponds to the offender taking accountability of his offense, restorative justice focuses on restating the losses suffered by the victims of crimes, holding the wrongdoers accountable for the harm they have caused, and promoting goodwill within the society. The concept of restorative justice treats crime as a wrongdoing against another person and the society rather than against the state. Its philosophy builds on the strength of both the people and the government to help integrate or restore the offender back into society as productive social beings. Rather than measuring the severity of the punishment inflicted for a particular wrongdoing, it measures how much harm has been repaired or prevented. Admittedly, the problems plaguing our criminal justice system such protracted trials, prolonged resolution of cases, lack of legal representation, and poor living conditions in jails and detention centers all add up to the lack of opportunities to reform and rehabilitate the offenders. However, given the effectiveness and value of the discussed developments in criminal law, procedure, and jurisprudence in addressing the problems of court congestion and case delay, I harbor no doubts that our common commitment to prompt and responsive justice for those who need it the most will be fulfilled. To this end, it is both my personal and professional commitment to take part in the undertakings of the Supreme Court towards the realization of a judicial system that is fast and restorative as it is fair and impartial. Thank you very much for your presence. Good afternoon. Mabuhay po tayong lahat. Thank you.
Thank you, Mr. Justice Peralta, for that brief but very informative and incisive lecture. Yes, that is brief because Justice Peralta is used to giving whole-day lectures. And also, thank you for conferring on me my doctorate degree, Mr. Justice Peralta. Let us now listen to the reaction of the former judge of the then Manila Fiscal Diosdado M. Peralta, retired Supreme Court Justice and now Vice Chancellor of the Philippine Judicial Academy, Mr. Justice Romeo J. Callejo, Sr.
Acting Chief Justice Antonio Carpio, the incumbent justices of the Supreme Court, Chancellor, Court Administrator Ada Frascuna, Court Administrator Juan Maidas Marquez. I'm asked to state my reaction. Ang aking reaction ay very brief. Res ipsa loquitur. Pero I remember a statement of Justice Benjamin Garduzo of the United States Supreme Court when he said, "There is no guarantee of justice except the personality of a judge. Let us look at the personality of Justice Peralta. Ang sabi niya kanina, nag-succeed yung continuous trial. Bakit? On the implementation of the revised guidelines on continuous trial of criminal cases and approved by the Supreme Court in 2017, Justice Diosdado and Peralta himself conducting training seminars from 2017 up to 2019. Imagine, an incumbent justice of the Supreme Court conducting training seminars on continuous trial, not only in Manila, but in all regions in the Philippines. Now he is in Metro Manila, tomorrow he is in Davao, the next day he is in Lawag, and the other day he is in Cagayan de Oro. That is the reason why the continuous trial has been very, very successful because of Justice Diosdado Peralta's constant and persistent efforts to teach and guide our judges, MTC judges, first-level judges, PAO lawyers, public attorney, and then public prosecutors, even clerk of court, courts personnel, and even policemen, all together in one room under the continuous lectures of Justice Peralta on continuous trial. To Justice Diosdado and Peralta, his lectures during the training seminars was a mission, a crusade. You can see his determination. Kaya kung minsan sasabihin sa akin, ikaw ang mag-opening remarks. Saan? Sa Davao. 2 days after that, sabihin sa akin, mag-opening na naman. Saan? Sa Cagayan de Oro. Pagkatapos, nandun kami sa Lawag, Ilocos Norte. No matter how well-crafted the revised guidelines may be, but if the same are not complied with, correctly applied, and meticulously implemented by the stakeholders, such guidelines are for naught. Obviously, it is justice we are after, and that is where carefully and purposely such as court annex mediation movement permits us to head. But justice includes both speed and fairness. It combines swift, efficient adjudication with a policy of preserving due process as a meeting of arriving at the truth. Hindi nagbago si Justice Peralta. Mula noong 1988 pa, ganyan na talaga ang ugali niya. Very tenacious, persistent, at saka naman perfect. Nagkasama kami niyan noong 1987. Ako'y judge ng Branch 49 ng RTC ng Manila. Ako'y hindi kontento sa services ng ating prosecutor. I asked for a replacement. Lo and behold, a miracle just happened. Judge Peralta, then Prosecutor Peralta, was newly transferred to Manila from Lawag, Ilocos Norte. He became my public prosecutor. I asked that he be the public prosecutor, only one branch of the Manila RTC. At nagkasama kami niyan hanggang 1994. Taon-taon outstanding public prosecutor of the City of Manila. Taong-taon yan. Yun ang typical recidivist. And in the process, hindi lang ngayon nagkita-kita tayo sa Metrobank. Binigyan siya ng award, Chief Justice Cayetano Arellano Award for Judicial Excellence. Sabay sila na Chief Justice Lucas Bersamin nung araw. Again, let us thank Justice Peralta for his efforts in helping the judiciary. As I said, res ipsa loquitur. Salamat po.
Thank you, Mr. Justice Callejo, for that also brief but enlightening reaction only His Honor can come up with. We have a brief period for an open forum. So if there are some brave souls who would like to ask a question or two, please approach the microphone at the center aisle. Just please state your name and your position if you're a member of the judiciary so that we can take note of you. Okay, so going. There's one.
There are sentiments that the GCTA, I'm Attorney Ruth Magpayo from Metrobank, that the GCTA should not apply to offenders who are employed in banking institutions because of the nature of the business, which is imbued with public interest. So I'm just conveying that.
Anong question? I did not get the question. You're referring to the good allowance?
It's not a question, Your Honor, but more of a manifestation that
manifestation.
there is a sentiment that the GCTA should not apply to offenders who are or who were employees of the bank when they committed the crime, such as qualified theft, for example, because of the nature of the business of the bank, which is imbued with public interest.
I think you need to have an amendment of the law because the law specifically provides who are those disqualified.
Yes, Your Honor.
There are four. For final sentence, there are four who are disqualified. Habitual delinquents, recidivists, escapees, and those who are convicted of heinous crimes. For the preventive imprisonment, there are 6 who are disqualified. Those who were asked to appear before the court but do not want to appear, and then the escapees, then the recidivists, the habitual delinquents, and then those who are charged with heinous crimes. The one that you asked me is not one of those who are disqualified to be entitled to the good conduct time allowance. What you can do probably is to have it amended. You try to convince the Senate.
Okay, thank you, Your Honor.
Okay, any other questions? Going, done. Okay, so I think there are no more questions. So just to briefly break the seriousness of this afternoon's discussion, let us welcome back and listen to the musical number of the multi-awarded Supreme Court Choir. Thank you again to the Supreme Court Choir for their excellent rendition of Isang Bangka, originally by the Dawn, synchronized with a slide presentation of last year's lecture. We now move to the presentation of the paper to the Metrobank Foundation by the Chairholder. May I call on Mr. Justice Peralta and Mr. Sobre Peña. Also the Chancellor, please. Thank you, gentlemen. May I request Mr. Sobrepeña and the Chancellor Ascuna. Ano yun? Teka. Paper pa lang yan. Hindi. Bababa muna sa Peralta. Okay. Thank you, gentlemen. Now for the presentation of the paper to the Supreme Court of the Philippines by the Metrobank Foundation. May I also call on Senior Associate Justice Carpio. Yun na yan. Thank you, gentlemen. You can now take your seats, except Mr. Sobrepeña. Now we move to the presentation of the endowment to the Chairholder by the Metrobank Foundation, but I'm not very sure on whom to call, whether our lecturer or his Chief Justice, Madam Justice Fernanda Lampas Peralta. So may I please just call both of them to the front. For the presentation of the plaques of appreciation, let me first read this testament of the text of the Testament of Gratitude. Republic of the Philippines, Supreme Court, Philippine Judicial Academy, present this testament of gratitude to Metrobank Foundation Incorporated for significantly and steadfastly supporting the Academy's mandate of delivering continuing judicial education, allowing the members of the Philippine judiciary to benefit from the scholarly research and presentation of its professorial chair holders. This year's Metrobank Foundation Professorial Chairholder in Criminal Law, Justice Diosdado and Peralta, successfully presented his academic paper on the significance of recent developments in criminal law, procedure, and jurisprudence to the Philippine Judicial System. At the 16th Metrobank Foundation Professorial Chair Lecture, by these presents, we express our gratitude and acknowledge the contribution of the Metrobank Foundation Incorporated to the success of this program. Given this second day of October 2019 at the Supreme Court and Banc Session Hall, Supreme Court New Building, Manila, signed Honorable Lucas P. Bersamin, Chief Justice of the Philippines, and Honorable Adolfo S. Ascuna, PHILJA Chancellor. The next plaque, may I read the text? Republic of the Philippines, Supreme Court, Philippine Judicial Academy, present this academic recognition to Justice Diosdado M. Peralta for the excellent presentation of his academic paper entitled The Significance of Recent Developments in Criminal Law, Procedure, and Jurisprudence to the Philippine Judicial System, given at the 16th Metrobank Foundation Professorial Chair Lecture this second day of October 2019 at the Supreme Court and Banc Session Hall, Supreme Court New Building, Manila, signed Honorable Lucas P. Bersamin, Chief Justice of the Supreme Court, and Honorable Adolfo S. Ascuna, PHILJA Chancellor. Last but not least, the academic recognition is presented to Honorable Romeo J. Callejo Sr. for being the reactor during the presentation of the paper entitled The Significance of Recent Developments in Criminal Law, Procedure, and Jurisprudence to the Philippine Judicial System by Honorable Diosdado M. Peralta at the 16th Metrobank Foundation Professorial Chair Lecture, which the Foundation sponsored to provide assistance to the Philippine Judicial Academy as it continues to develop and enhance programs in judicial education to promote competence, excellence, and efficiency in the Philippine judiciary. Given the second day of October 2019 at the Supreme Court and Banc Session Hall, Supreme Court, New Building, Manila, signed Honorable Lucas P. Bersamin, Chief Justice of the Philippines, and Honorable Adolfo S. Ascuna, PHILJA Chancellor. Thank you, gentlemen. You may now sit down. To close this 16th Metrobank Foundation Professorial Chair Lecture, may I now call on the 148th Justice of the Supreme Court, Senior Associate Justice Antonio T. Carpio.
Good afternoon. After that lecture of Justice Dado Peralta, now you will know why we call Justice Dado our resident expert on criminal law and criminal procedure. In our deliberations in the Banc, when Justice Dado speaks on criminal law and criminal procedure, we strain our ears to listen to him. Of course, Justice Dado also is known as the champion, the untiring champion of continuous trial in the Philippines. So Justice Dado, thank you for enlightening us this afternoon on the recent developments on criminal law and criminal procedure. I wish to thank also the Metrobank Foundation for sponsoring the 16th Metrobank Foundation Professorial Chair Lecture in partnership with the Philippine Judicial Academy. I hope that this partnership will continue in the coming years. I wish to thank also all those present here this afternoon for your attendance. Thank you and a good day to everyone.
Thank you, Mr. Senior Justice Carpio. Before we end, may I just remind those who are getting credits for MCLE to submit their completed forms to the Secretariat at the entrance of the session hall. Let us now all stand for the Philippine Judiciary Hymn. Thank you, everyone. That ends our program. Everyone is invited to have some refreshments outside the session hall. Thank you.